Hi folks, this is Jack with Richmond Law Group. I'm going to start off with a few announcements before we begin. We are going to start promptly at 12:05 to give folks time to log on. And in the meantime, please familiarize yourselves with the question feature by typing in who you are, who you're representing, and where you're tuning in from. Feel free to use this feature during the presentations to ask questions. Sage from Richmond Law Group will be actively responding. And at the end of the presentations, she will pose your questions to the panelists. Stay tuned and we'll be starting soon. Thank you. Hi folks, this is just another announcement that we will be starting at 12:05. In the meantime, you can familiarize yourselves with the question feature, and I'm also going to put out a poll asking you what type of advocacy role you play in your organization. And if you could fill that out, that would be great. Okay, it's now 12:05. I'm going to ask that our panelists turn on their microphones and their webcams, and we will begin. Kim Richmond will lead us off.
Thanks, Jack. I'm going to get started momentarily. Hopefully everyone can both hear and see me, and we'll get started just in a moment. Okay. All right. I see we, in fact, have everyone here, and welcome back, everyone, to the 2020 Food Systems Summit. I first want to give a shout out to our co-host, CUNY Urban Food Policy Institute, and some of the instrumental folks heading up the Institute, namely Craig Willingham and Nicholas Freudenberg. And they are really pushing the edge on food policy. This book by Nick, Lethal but Legal, really cuts to the core of a lot of the law and policy issues that we have been tackling on the various panels. Speaking of the panels, they have indeed been snowballing in dynamic ways. This is our third official panel. We've got 3 more the following Thursdays at high noon Eastern time. But they have indeed been snowballing in unexpected and expected ways. Indeed, in panel 1, we kicked it off with multidisciplinary approaches to law and policy in and around our food systems, as well as potential cross-pollination between movements ranging from environmental to animal rights. As folks may recall, in panel 2, we heard from multidimensional advocates beyond your traditional legal advocates. We heard from Larry Bolin from the Health Research Institute, who is heading up an independent lab and doing some really great work in terms of putting our food systems literally under a microscope to create ultimate transparency. Karen Howard from the Organic and Natural Health Association is one of the emerging progressive trade associations that we have seen hit the scene. We've also heard from another unusual advocate, business owner Matt O'Hare of Vital Eggs, who is really pushing the envelope, redefining how to effectively create a healthier food system and not just focus on the one bottom line of profit. Panel 3 today, we'll hear shortly from our moderator, Jason Rathode from panel 1, who's going to kick it off and help facilitate a discussion on multi-legal approaches to address broken food systems beyond standard administrative actions, as well as consumer protection class actions, which are increasingly disconnected from repairing the world. So today we will hear shortly about other very creative and effective legal approaches. As to the unexpected ways the summit has been snowballing, we do not expect immediate call for action on a host of matters, and already working groups have been organizing. Talk of Zoom workshops are underway, as well as chatter about virtual screenings of documentaries and other grassroots efforts. But without further ado, it's my pleasure and honor to now turn it over to Jason to kick it off for panel 3. So thank you, Jason.
Thank you so much, Kim. And thank you to the Richmond Law Group as a whole and the City University of New York Urban Food Policy Institute for putting on this great event. My name, as Kim said, is Jason Rathod. I'm a plaintiff side class action attorney and founding partner of the law firm Migliaccio and Rathod LLP in Washington, D.C. We focus on bringing plaintiff side class actions on behalf of consumers, workers, as well as bringing cases in the arenas of civil rights and environmental contamination. And I'm also, as Kim mentioned, your moderator today. Our topic is fighting for food policy progress across legal arenas. And the areas of law covered will be varied, and it'll include antitrust law as one major focus, and also advocacy and litigation for animal welfare. And these are really critical topics really at any time, and particularly now. With antitrust, there's strong implications for how the economy is structured. There's few areas of law that can really reshape a whole economy, and antitrust is one of them. One thing that's striking as you go through the legislative history of major antitrust statutes in the late 1800s and early 1900s is how there's an animating concern about a transfer of wealth and power from consumers and small producers to big business, and how antitrust laws could combat that. With animal welfare, advocacy, and litigation, at the center of many of those disputes today is really an effort to call attention to and end appalling practices that are often the result of large-scale industry seeking to turn a profit at all costs. in thinking about these topics and doing my own personal reading about pandemics during this time, I was struck by some of the linkages between the ills that these fields of law are meant to address and also deadly pandemics that we've seen over the past 50 years or so. And there's a lot of really excellent writing on these linkages, and I'm thinking in particular of the works of folks like Rob Wallace and also Mike Davis that have carefully explained how bad large-scale industrialized agricultural practices have increased the likelihood of the spread of deadly pathogens. And we could think of a prominent example locally would be the avian flu in 2015. It really ravaged chicken and turkey farming operations throughout the Midwest primarily. And it spread like wildfire because of factory farming practices, stacking genetically identical chickens on top of one another in enclosed spaces. And there wasn't animal to human transmission there in the same way that we see with coronavirus, but we have seen that in other parts of the world with similar root causes. So in West Africa, for example, industrialized agricultural practices bear responsibility for some of the spread of deadly pathogens and diseases, such as Ebola. We could look to practices such as overfishing, which in West Africa off the coast of Guinea, for example, really sparked a transformation in the diet of many people from a cheap source of protein, fish, to bushmeat, which became a substitute once fish became unavailable. Also see it with logging and deforestation. Previously, it's a natural barrier for some of the more exotic species of animals. With that gone, there's increased interaction between humans and animals and greater likelihood of the transmission of deadly disease. We see the same pattern play itself out in the Middle East and China, and potentially now in the Amazon as we see deforestation there as well. In a recent interview, Rob Wallace was asked, what is to be done to make us safer from future pandemics like COVID-19 and like some of the others that I've spoken about? And he said, we really need a core reform of global agribusiness and the way they do business. And what he said was pathogens have the best lawyers on the planet. And what he meant by that was that there's strong lobbying and legal apparatus that props up this industry and its worst practices. And it turns out a huge profit every year, but it externalizes the cost to the rest of all of us. And luckily on our side, we have strong advocates and litigators as well to help fight back. And some of those are on this panel today. So without further ado, I'll present you with our first speaker, who's Nathaniel Gideon. He's a partner at Hausfeld LLP in Washington, D.C. And I should note that his partner, Michael Hausfeld, has been instrumental in the spread of antitrust law throughout Europe and other parts of the world with strong private rights of action. Nathaniel's practice is focused on antitrust and consumer litigation. He was a member of the direct purchaser plaintiff class in the trial team in in-ray processed egg products antitrust litigation. So Nathaniel, I'll hand it over to you.
Thanks, Jason. Hello, everyone. Good afternoon. Happy to be here. And Cam and Richmond Law Group, thank you for having me today. I'm really excited to be here. As Jason mentioned, I am a partner at Hausfeld LLP in Washington, D.C., where my practice focuses on antitrust and consumer litigation. I do have food antitrust experience, including the eggs antitrust case that went to trial last year in Philadelphia Federal Court. I'm originally from Michigan, from a cow town, a little small town, literally in the middle of a cornfield, and I'm a graduate of Michigan State University, which some of you may know started out as Michigan Agricultural College. So I'm really happy to be talking about this. Ag law and food systems is something I'm passionate about. So if we can go to the next slide. So just very quickly about Hausfeld. So the firm is about 11 years old. It was started by Michael Hausfeld, as Jason mentioned. And I've been with the firm for about 9 years now. We've started with about 20 or so attorneys and a couple of offices, and now we've grown to more than 100 attorneys in a dozen different offices around the world. The firm is focused on antitrust litigation, but we also do extensive work in areas like consumer, data breach or privacy, mass torts, and environmental work. We've got some really interesting global warming cases right now, too. But the attorneys at Hausfeld have, in various points of their career, been involved in what I like to call the breakfast cases. And if you think of the traditional American breakfast plate, There are antitrust cases involving basically everything on that plate: pork, eggs, and potatoes. And the attorneys at Hausfeld have been involved in all those cases. So if we can go to the next slide. So as Jason mentioned, the antitrust law is about 100 years old. Its basis is in the Sherman Act, which was enacted in 1890, and it was in response to trusts, which were basically large pools of competitors that they pooled their resources and their interests together to make sure that they wouldn't compete with one another. And so the antitrust was the law to prevent that from happening. That's why it's called antitrust. Some of the early examples of antitrust cases that people might be familiar with would be like Standard Oil or Alcoa or US Steel. But since that time, antitrust has touched basically every aspect of the American economy and also now the worldwide economy. So if we go to the next slide. So just a little bit more about antitrust, and some of you in the audience might not be familiar with what it is. So generally speaking, the Sherman Act is intended to preserve free and unfettered competition in the marketplace. And most of the time when people think about antitrust law, they think about what I like to call hardcore antitrust violations, right? And that's what 15 U.S.C. Section 1 talks about. And that's contracts, combinations, or conspiracies in the restraint of trade. That would be horizontal competitors, people at the same level of the distribution chain, agreeing to restrain trade in some capacity. That would be things like price fixing, group boycotts, where you say, hey, we're not going to let this person compete with us, agreeing to reduce supply, and agreements not to compete with each other. And that's what would be called a horizontal per se violation. Now, there are other types of antitrust restraints that are also actionable. And some of those restraints are what are called vertical restraints. And those are agreements or cooperation between different levels of the distribution chain. So if you think of like minimum advertised price policies or manufacturer suggested resale price policies or retail pricing policies, those could be violations of the antitrust laws. They are not what we would call hardcore necessarily violations, and they are judged by a different legal standard called the rule of reason. But depending on the facts, they may or may not run afoul of the Sherman Act. Two other intricacies of the antitrust laws that I think are worth mentioning today is the direct versus indirect distinction. Now, under Supreme Court precedent, the Illinois BRIC case, the federal antitrust laws, private claims, civil lawsuits are limited to what are called direct purchasers of the price fixed product, or the first purchaser of the product that's been restrained. Since that Supreme Court case, about 30 or so states have enacted what are called colloquially Illinois BRIC repealer statutes. And those say under state law, people further down in the distribution chain can bring their own civil lawsuits against the same antitrust violators. So what you could see in these cases, and what we do often see, is there are federal antitrust law claims by direct purchasers, and then state antitrust law claims on behalf of what are called indirect purchasers. The last thing I wanted to mention, the antitrust laws, at least the federal ones, provide for treble damages, which are intended to be a deterrent from future anti-competitive conduct. And that provides that if you go to trial as a plaintiff and win, you're able to cover triple or treble the amount of your actual sustained damages. So can we go to the next slide? So antitrust law has touched food systems and food production for decades. Some of the earliest cases, there's cases from the 1940s and even earlier involving grocery stores, but in the 1940s involving dairy cooperatives. And on the right of the slide here are just cases that have been filed, some of the cases that have been filed between 2004 and 2019 involving different food products. And the Hausfeld firm and I myself have been involved. I've been involved in one of these, and the Hausfeld firm has been involved in multiple of them. And as Jason mentioned at the outset, the growing consolidation of the food systems here really makes antitrust law a much more acute concern, right? Just think about it logically. It's much easier to form a conspiracy if you have 3 competitors versus if you have 30 competitors, right? So it's a lot easier to act on your anti-competitive impulses. And that's, I think, why we have seen an uptick in potentially anti-competitive conduct in food systems. I mean, we all know that there's been a ton of consolidation in these markets. One unique aspect of antitrust law in agriculture is what's called the Capper-Volstead Act. And everyone, I think, on here understands that farmers have always had a special place in Congress's heart. And what Congress did is they passed this law that basically, in a narrow set of circumstances, exempts farmers from the antitrust laws. Basically, the thought behind it is you can get together and form an agricultural cooperative to jointly market your products. And the thought was that would help farmers, small farmers, stay in business and make a reasonable return on their products. Now that law is also very old, almost as old as the Sherman Act. And, you know, personally speaking for myself, I think the agricultural markets are very different today than they were when the law was enacted, and query whether something like that makes sense with how much consolidation and how these huge multinational agro companies are doing business today. I'm not in Congress. I don't get a say in it. It's just more of an intellectual curiosity than anything. But one of the cases I do want to talk about is the broiler case, the broiler chicken case. And I wanted to focus on this case. It's ongoing. The Hausfeld firm is involved in it. I'm not personally involved in it. But I wanted to highlight it because I think it speaks to some of the flexibility in the antitrust laws and also the complexity in the antitrust laws that I've started to or touched on briefly already today. So can we go to the next slide, please? So as I was preparing my presentation today, my wife said, well, what's a broiler chicken? That's a good question, but generally speaking, a broiler chicken is a chicken that is raised for meat. If you go to Chick-fil-A, if you go to a Peruvian barbecue place, that's probably a broiler chicken. And the market for broiler chickens is controlled, for all intents and purposes, by a small group of very large companies, right? Tyson's Food, Koch Foods, to name a few. And what happened here, so this case was filed originally in 2016, and it involves 3 different classes or putative classes of impacted plaintiffs. So the first is the direct purchasers, right? The people who purchased the broiler chickens directly from Tyson's and Koch. Then there's the indirects under state law. And then there's a third group on behalf of the growers, the people who are producing the chickens themselves. And they're all bringing antitrust claims, but they're antitrust claims of slightly different stripes. But the general theory of the case is the same. The vertically integrated companies used something called agristats to share commercially sensitive information in order to fix the price for broiler chickens. And this case is interesting because not only does it involve multiple different classes, right, alleging all antitrust claims, I think demonstrating the flexibility of the antitrust laws, but it also resulted in the federal government acting on it. So the civil suits were filed in 2016. In 2019, it came out that a federal grand jury was convened to investigate the same wrongs that were alleged in the earlier filed private lawsuits. So here we have the antitrust laws, the private bar, spurring government action, which I think is very interesting and important from an advocacy perspective as well. And So the household firm is involved in the grower case, the people who are actually producing these chickens. And I think from my perspective, that's interesting because the allegation there is that they used AgriStats to basically squeeze these farmers' margins and didn't allow them to jump between different companies if they wanted to try and make more money. The other interesting thing from an animal rights perspective is that the contracts with the growers and the companies are very restrictive about what they can and can't do with their chickens. So if you're a farmer and you say, hey, I want to provide a higher level of care for my chickens, I want to give them more space, I want to give them more sunlight. In theory, that could run afoul of your contract with the company, and you could lose your livelihood, right? And so that, coupled with the fact that you basically aren't allowed to switch between different producers, means the growers are more or less forced into complying with the situation that they're in, and that I think is detrimental from moving the market forward, but also improving the animal welfare of the chickens that they're growing. And with that, I look forward to people's questions. And I guess I should have said at the outset, I'm speaking on behalf of myself, and it's been a real pleasure to be here, and thanks again. So back to you.
Excellent. Thank you so much, Nathaniel. That's great. Our next speaker today is going to be Jay Schuster, and Jay is an associate at Richmond Law Group. His work is focused on animal welfare litigation, and his topic is consumer watchdog litigation, some of which I've joined Kim Richmond, this firm, in bringing as well in DC. But Jay, he strives to combat all forms of discrimination as a part of a broad coalition of advocates working for food justice, workers' rights, environmental protection, and animal rights. So Jay, take it away.
Thanks, Jason, and Nathaniel, thanks for the reminder for me to say that I'm speaking directly on behalf of my employer, Kim Richmond, and everything that I say that's wrong or bad, you can attribute directly to him. So yeah, you give a little bit about my background. I've been an animal rights activist for about 10 years, but I also have a little bit of background in human rights and national security as well. And today, yeah, we're going to talk about consumer watchdog litigation, which is basically a term that we use to distinguish the consumer protection work that we do from your standard class action lawsuit that you might think about in the consumer protection context. And basically, in a class action that you might see on TV, did you buy this product? Call our firm and we'll represent you. In standard class action, you have consumers who purchase the products that are seeking damages, money for the purchase of the products when they were misled for one reason or another to buy a product. But here we're talking about a consumer protection case brought by a nonprofit group that is seeking to just stop the advertiser from making the false and misleading claims. And so today I'm going to give a few examples from our lawsuit against Tyson Foods, very popular these days. And yeah, so if we go to the next slide, Jack, that'd be great. So the kind of basis of our work is something that we call the trifecta approach, where historically we've addressed three main issues through our false advertising litigation. Basically, the general idea is that companies, when they claim that they are good for the environment or good for animals or make any kind of sustainability claims along these lines, we can actually hold them accountable for doing that. And we focused historically on the environment, animal welfare, and public health. But recently, we've been moving to add labor claims, labor rights claims to our work. And as you all know, it's really more timely than ever. And the reason that we do this is, well, twofold. One is really just because we think that they are interconnected issues, and it's really just frankly difficult to talk about any one of these issues without implicating all of the others. But also, it just helps demonstrate the importance of all of these issues to the court or to the broader public who perhaps maybe doesn't care about any of these individual issues in isolation or cares about one issue and not another. If we can really address it in a comprehensive fashion, we know that we can really demonstrate the true importance of the issue as a whole. And if you know anything about any of these fields and you're joining us here today, you probably think that the laws and regulations that actually govern animal welfare, the environment, public health, and labor are not so good. And that's really no more true anywhere than it is true for farm animals, where the laws governing the treatment of animals on the farm are either completely non-existent or completely unenforced. And so actually this gets to the reason why I got involved in this work at all. And that's because even if we can't hold a company liable for exploiting its workers or even torturing animals or dumping pollution into the environment, we can at least hold them accountable when they lie about not doing those things. And so it really provides an important avenue in areas of law where the substantive enforcement, the actual governance of the practices that companies can engage in are very weak. It provides an opportunity for nonprofits to step in and at least help to hold these companies accountable for the wrongs that they're doing. And so that actually gets to another broader point I wanted to make that is really exciting about this work is that when we bring these types of cases, we can actually really expose often what undercover investigations of farms are unable to do. And that's that we can really expose the systemic nature of the practices that these companies are engaging in. So we often say that we don't just investigate the farm, we are investigating the boardroom, and we can demonstrate to the court and beyond that standard business practices and systemic harms are actually ratified by the highest levels of the company. And so that's a really exciting aspect, I think, of this work. And especially if, as folks know, in the animal advocacy world, it's so common whenever something, an egregious incident occurs, the company just makes this bad apples argument saying it was just, oh, it's these workers that are to blame. And we can really help to show in a systematic way to the court and to the broader public that no, this is how these practices are actually standard business practices that the company, as Nathaniel was saying before, will even require their farmers to engage in. So next slide, please. And these are some of our partners that we are really excited to work with. And as you can see, it spans not just animal advocacy organizations, but also environmental organizations and consumer protection organizations focused more on public health issues. And yeah, again, just having this kind of dynamic approach with organizations that are addressing the issue from multiple perspectives, we think really goes a long way in communicating the seriousness of the issues that are at stake. Next slide, please. And as I was saying before, we don't just put these companies on trial in the court of law, but also these cases have the effect of putting these companies on trial in the court of public opinion. And these are just a few examples of the companies that we have filed suits against: Tyson, Hormel, Ben & Jerry's, the largest foie gras producer, it's called D'Artagnan. There's also other companies like Pilgrim's Pride and Sanderson, where in the chicken industry, we really have gone after all the largest players. And yeah, as you can see with a lot of these headlines, we can really expose, not just to the court, but really beyond what's actually going on systematically in these companies. And as you can see with the Ben & Jerry's example, we can actually lead these companies to take down these most misleading claims and show the public basically that these companies are not even willing to stand by some of these claims of humane treatment or environmentalism. So yeah, if we go to the next slide, please. So I don't want to bore you all with too much legal technicalities, but these are just really important doctrines, standing and preemption, that I think are just very important for anyone that is in the nonprofit space. You may have heard of some of these issues before as being kind of the bane of existence for anyone that wants to, any nonprofit that wants to bring a lawsuit. And standing in the animal world is always an issue, and because standing is this basic concept of what I will grossly simplify as the right to sue in any particular case. And the problem with animals is that typically, in order to sue somebody, you can't just sue them because you think they're doing something illegal. You need to show that you personally, the entity that is suing, was injured in some way. And that can be really tough when you're working in the animal advocacy world, where it's often, as advocates, we think, no, the animals are injured. They're the ones that have suffered the injury. But we need to show that it was, to have your day in court, you need to show that your organization was actually injured. And that can be a real challenge in the false advertising context. And so what that's meant that historically in false advertising cases, the nonprofit will argue that they spent time and money basically being forced to combat the false advertisements that were made by the company at issue. But unfortunately, the law in that area, it's unpredictable, to say the least, and it can be a burden on nonprofits who need to then prove that they expended resources to fight these false advertisements, and they may have to dig up all sorts of records and sit for depositions where they're going to be grilled and having to show that what resources they expended and why. And so that's why we are really excited about our practice where we focus in Washington, D.C., which has a really excellent consumer protection statute that provides a much more straightforward path to standing for nonprofits. And I'm not going to get into all the ways it does that, but one of the ways that we rely on that's really effective that I think advocates should be aware of is something called tester standing, where if your nonprofit tests or evaluates the product at issue for something that consumers care about, for example, maybe that's the use of a certain chemical, and you send a meat product, for example, off to a lab, then you can almost, I don't want to say automatically, but it's a very straightforward path to getting standing, where you don't have to get bogged down and spend countless hours litigating that issue because you meet the very straightforward requirements in the statute. That brings me to the next bane of my existence as a false advertising lawyer, which is preemption. And I definitely don't have time to get into detail on this, but a very, very brief summary for our purposes here is this idea that when a label on a product is approved by the USDA itself, that label will become effectively immune from being the subject of a state false advertising lawsuit that we might bring in DC or under California law. And so what that means for us is in the meat and dairy, or in the meat and poultry context, we go after everything but the label. So that's advertisements like television ads, social media ads, websites, sustainability reports, YouTube, etc. And it's really, on the one hand, we would love to be able to go after the label, but on the other hand, it's really exciting when you can go after this entire wide range of advertisements in these cases and entire marketing campaigns that are deployed across these various media. And I'm not going to get into too much detail here, but just for folks who are interested in these in the details here, these same preemption issues are different in other contexts like eggs, fish, dairy, and pet food, and it's very tricky. And again, we don't have time to get into all the details here, but there's a lot more room to go after the product labels themselves, which are obviously the advertisements that are most likely to be viewed by any particular consumer. And as I was saying before, one of the great things about doing these nonprofit cases as opposed to an action on behalf of a consumer who purchased the product is that, unlike in a class action where we're trying to get monetary relief for people who bought the products, we don't actually need to prove that millions of consumers relied on every single ad that was, each tweet that came out or each Instagram post. We really can go after all of them in a much more comprehensive way without getting bogged down in issues of, oh, did your particular client see this particular ad in this particular place? And so it enables you to go after broad advertising campaigns in a way that is very challenging to do in the standard class action context. And again, if the key question here is really just if they're false or misleading, and if they are, then we can get a court order to have the company remove the ads. So I think now we can go to the next slide. Just for some examples here. So as I said, here's an example from our case against Tyson of the sort of, one example of a type of ad that we might, pursue in litigation. And it's a little tiny on my screen here, but one of the lines here that I find most interesting and deceptive is where they don't just say that they are going to provide humanely treated chickens for people, but they actually say they're going to provide consumers the most humanely raised food possible. And we really like these type of comparative and superlative claims, just from a legal standpoint, because it's often, more concrete to just show that a company like Tyson, they are literally defining standard industry practices. They're not exceeding them in any way or attempting to exceed them. And so it's it's very concrete to show when companies make these types of comparative claims that it's simply false to say that they are doing certain things. And I'll also note that you may see at the beginning of that sentence, they have language like "we are committed to," but again, because the key question is whether the particular ad tends to mislead consumers, these type of statements that are maybe considered aspirational claims are still fair game. And there's a lot of great case law where courts have said you can't just slap on this type of weasel language like "we're committed to" and then be immune from false advertising liability, because consumers rely on these types of claims that companies make. So now I'll just show you another example briefly of another ad on the next page. So this is just a YouTube ad, "Do Tyson chickens live healthy lives?" And again, here we would marshal all sorts of evidence in these types of cases showing basically that is not true, that animals are often sick, et cetera, in these farms. And I think I'll just wrap it up by saying, talking about a little bit about what you can expect in these types of cases in terms of the relief that's available to the nonprofits that are pursuing them. At the end of the day, the fundamental purpose of these cases and these laws allow you to do is to compel companies to remove the false advertisements at issue. And I'm not going to get into a ton of detail here, but it's important for any advocates here to know that we can often negotiate in the process of the litigation for changes that go beyond just changing the advertisements. And companies in the past, we've successfully gotten them to actually bring their production practices more into accordance with the claims that they were making. And that's obviously the best outcome for us and for our nonprofit partners, who obviously want to see these companies stop misleading consumers, but they also really want to see these companies live up to the practices that they're claiming. And so with that, I think I will wrap it up. So thanks again to everyone for listening, and looking forward to answering any questions you all may have.
Excellent. Thank you so much, Jay. That was very informative. And our next speaker is Dina Jones. And Dina has 30 years of experience advocating for animals. For the past 10 years, she has led the Farm Animal Program at the Animal Welfare Institute. She holds a graduate degree in public policy from Tufts University School of Veterinary Medicine. So I'll pass it to Dina.
Can you hear me all right? Yes, people are nodding. Okay, thank you. Thank you, Jason, and thanks to Richmond Law Group for organizing the Food Summit and for inviting me to participate. Some of you may not be very aware of the Animal Welfare Institute, so just quickly, we are public policy focused, as it mentions on the slide here. And that means we do state and federal legislation, we do litigation, and we do a lot of administrative agency work. So for the farm animal team at the Animal Welfare Institute, we base our work on our own research. We're the only group really in the United States that is completely, comprehensively researching the treatment of farm animals and state and federal oversight of the few laws that we do have for farm animals. And we do this by filing, yes, a lot of public records requests and Freedom of Information Act requests. So last year, I think we did more than 100 public record requests to state and federal agencies regarding the oversight of these agencies for farm animal welfare laws. So one of the areas that we research is government approval of animal welfare and environmental stewardship claims on packages of meat, poultry, eggs, and dairy. I think for a long time, food advocates have assumed that there's been very poor oversight of these claims, but nobody has really been able to demonstrate it. about 10 years ago, we started requesting label approval files from the USDA. So we were looking for the substantiation that the government was using to approve these claims. And we've looked at more than 100 label approval files over the last decade having to do with animal welfare and environmental stewardship claims. And as a result, we've published 2 reports and been able to demonstrate that, yes, obviously, there is deception and inaccuracy in these claims. I think it goes without saying that deceptive and inaccurate claims on products promote factory farming and an unsustainable food system. It threatens the consumer's ability to find products that are consistent with their personal values, and it is also a major barrier for higher welfare sustainable farmers. I think if you ask higher welfare sustainable farmers in the United States to identify the biggest risk to their livelihood, many of them, if not all of them, would identify poor government oversight of advertising claims as biggest threat to their livelihood. So let's move on to the next slide. So I've been asked to speak about one tool that can be used to challenge these misleading, deceptive claims, and that is the National Advertising Division of the Better Business Bureau. And the reason why the NAD process, as it's referred to, is so important is because it avoids or eliminates some of the major problems that you're encountering with litigation and complaints before administrative agencies. Jay just mentioned 2 barriers being standing and preemption. Well, that's not a problem with this process, and that's why it's so important. This slide goes over some of the major characteristics of the NAD process, and yes, it is being used and has been used to challenge environmental, green, and animal welfare claims. Potential downside, although we'll talk about this a little bit more later, is that it's a voluntary process and not legally binding. The majority of the challenges are brought by competitors, but nonprofits, local Better Business Bureaus, and consumers can and do also bring challenges. And it's important to note that the NAD itself can open up a review of any claim that it might be suspicious about or suspects that is misleading and deceptive without receiving a challenge. This is the single largest body of advertising decisions in the United States, so it has a major impact on advertising law. They handle about 150 cases a year. The standard process, which is the process that my organization has used, takes about 3 to 6 months to resolve the challenge. But they also offer a fast-track, swift challenge that supposedly resolves the issue within a month. We haven't used it, so I can't really comment on comparing those 2 challenges. If the advertiser is unhappy and disagrees with the NAD decision, there is an an appeals process is available through the National Advertising Review Board. Let's move to the next slide. So this is kind of my take on the advantages and disadvantages of the NAD process. And I would say that I and many others feel that the advantages outweigh the disadvantages. As I mentioned before, it's a fast process, especially compared to litigation. It's low cost. There is a filing fee. Nonprofits can apply for a waiver. Our waivers have always been granted. There is an additional cost that has to do with the third bullet point here, and that is the fact that the NAD puts much emphasis, the most weight, on consumer perception. Because of that, you really need to commission public opinion surveys, because that's what they look at most. And those can be expensive. This isn't Gallup or Harris. This is a legal level, full-blown public opinion survey that can be more expensive than your typical poll. As I mentioned, preemption, less of a problem. So the NAD has been willing to consider cases where the government has approved a label claim, and it has made findings contrary to the government's approval process. It's been willing to do this, it has done this, and that means a lot to our work. Because this is the only thing they do, their staff has a lot of expertise and no legal representation. You don't have to be an attorney to do the process. But we do recommend that you get legal advice from counsel that is expert in this process, because it's different than litigation. For me, the biggest plus to the NAD process is that they have a close relationship with the Federal Trade Commission. And as you can see in the little asterisk below, 2017, 2018 cases, they did a little bit of review, and they found that of all those cases that were referred by the NAD to the FTC ended up taking action in 15 of the 19 cases. So the NAD the FTC puts a lot of weight on the NAD process and their findings. On the downside, decisions are non-binding, but remember, you can always go to the FTC as a fallback. So if a producer doesn't comply with the NAD decision, even though it's legally non-binding, if they don't comply, the NAD can refer to the FTC and they can make them comply. Litigation will close the case, will close your case, but I suspect that probably doesn't happen too often. The biggest downside, I think, for advocates is that the process is confidential and there's limited publicity potential. So you aren't allowed to do press releases. The NAD does its own. It works with the advertiser in the wording of that release. I think it's difficult to do the NAD process to put pressure on other advertisers other than the ones that you're challenging, and also to use it too much with the public for public education. So that's definitely the biggest negative. We found in one of our cases the NAD seemed a bit differential to the advertisers, so that's always a possibility. But on balance, more advantages. Next slide. I'm not going to go through this because of our time limitations, but here there's 4 different cases, I'll run through it real quickly, where farm animal raising claims have been brought to the attention of the NAD. In 3 of these 4 cases, the NAD found with the challenger that the claim was misleading and recommended that it be discontinued. So Compassion Over Killing challenged United Egg Producers Animal Care Certified on egg cartons, and the NAD recommended it be discontinued. D'Artagnan, we just talked about D'Artagnan. A while ago, the Humane Society of the United States challenged their express claim about liver not being diseased and animals being raised with tender care under the strictest animal care standards, found to be misleading, recommended that it be discontinued. There's been 2 cases between Purdue and Tyson. Twice Tyson has challenged Purdue on its advertising. In the first case, which was 2018, Tyson challenged Purdue's claims that chickens are happy and that they are raised organically. It implied that even the non-organic Purdue chicken came from organically raised chicken. NAD agreed with Tyson and recommended that it be modified. Then there was a bit of reversal in 2019. The NAD found for Purdue in a challenge by Tyson. Tyson felt that the Purdue advertisements were giving the impression that its chickens are raised free range and pasture raised, and the NAD disagreed and found that the claim was not misleading. But in 3 of these 4 cases, the finding was for the challenger that the animal raising claim was deceptive. Next slide, Jack. So I'm going to talk quickly about our experience at the Animal Welfare Institute with the NAD process. So we've had 3 cases, 3 different dispositions, and but all 3 resulted in the claim being removed. In the first case, we challenged Purdue's humanely raised and raised cage-free claim. The case was closed when litigation was filed, but the important thing here is in writing its report, the NAD was almost ready to issue its finding, and I believe was going to be in our favor. So they made 2 statements in their report that have been very beneficial to us and potentially to others. And that's number one was that the fact that the USDA approved this claim was not just USDA approved, it was USDA process verified. And the NAD found that they had the jurisdiction to look at this and that they were willing to find against the USDA approval. The second thing is that NAD will not look at an ethical question. We've been concerned about that in each one of our three, and in each time it is ended up not being a problem, because in each case NAD felt that the issue was consumer protection and perception of whether the claim was consistent with humane raising. So even though they said we won't say what is humane or not humane in the way an animal is raised, but we will consider how the consumer perceives it, and that's why you have to do consumer perception research. Next slide. So when our Purdue case was closed, we looked for another case so we could get a final decision on this issue of whether industry standard can be used to substantiate humanely raised. And we found Allen Foods using humanely raised on family farms on its chicken. We submitted our complaint to NAD, and almost immediately the company entered bankruptcy. And but told NAD that it was going to remove the claim. Fortunately, NAD reviewed our challenge and wrote a brief report saying they were closing the challenge because of the bankruptcy, but that they believed that the claim should be removed. And that turned out to be great and very, very important, because 18 months later, the claim is still on the package. So we went back to NAD, asked them to refer the case to FTC. They did. FTC contacted Allen's, and they agreed to not only remove the claim, but to become third-party animal welfare certified. So win-win in that case. Last slide. There you go. I'm sorry, next to last slide. The third case we did was just last year. It was resolved last summer. It was Clemens Food Group. We were challenging Hatfield's brand use of ethically raised claim on its pork products. And the claim is, believe it or not, very long, convoluted, ethically raised by family farmers committed to a higher standard of care governed by a third-party animal welfare audit. And looking at the claim, we found that they were using the common swine industry audit to indicate higher standard of care and a third-party animal welfare audit. And we challenged both. And since the common swine industry audit is the industry audit, it's clearly not higher and it's not third party. We did a public opinion survey, which was consistent with our view, and NAD agreed that the claim should be discontinued. It's off the internet, and they're working on taking it off of packaging. Last slide. So of those 7 different challenges that were in my previous 2 slides, in 6 of the 7 cases, the misleading claim has been modified or removed. So this shows what an important tool this is in promoting humane, more sustainable farming and fighting the promotion of factory farming and unsustainable food systems. So back to you, Jason.
Thank you so much, Dina. It's very informative. I didn't know anything about that process, so it's good to know there's another tool out there for sure. Well, I think that wraps it up. I believe Kim probably has some closing remarks and information about the next session.
Thanks, Jason. Thank you, everyone. I'm going to turn it over to Sage to ask some questions with the remaining time.
Yeah, and I'm yet again going to turn it over to Jack, who's just going to read some of the results of the poll in case anyone was curious.
Sure, thanks, Sage. So there's going to be one last poll before everybody leaves, and it's about participating further in the future. We just want to further organize everyone because we've gotten a tremendous amount of feedback on wanting to continue work past the Food Systems Summit. So if you could fill this out, that would be great. One second. And then while you're filling this out, Sage, go ahead and you can start asking questions of the panelists.
Thanks, Jack. All right, so we had one question for Nathaniel from Dana. And Dana was wondering if you could address what you defined as conspirator, because they say conspiracy is somewhat of a loaded term socially, and it would be helpful to know how to use this term appropriately from a legal perspective.
Yeah, I mean, obviously conspiracy, the word conspiracy has been in the news a lot over the last couple years. And I think really where you could focus on it is contract or combination, right? So the question is, do you have two independent economic actors who reach a meeting of the minds, like a contract? It doesn't need to be written down, it can be an understanding to do something that restrains trade, right? So that could be everything from, hey, we're not going to compete in the state of Ohio, right? Competitor A, you can have Ohio if I get Kansas, right? Whether that's written down or not, if there is a common understanding, that's potentially problematic under the antitrust laws. So really, you're just looking to make sure that both parties, or two or more parties, who are independent or supposed to be independent, have an understanding of how to behave as to a specific product.
Thank you so much. That's great. I was curious too. All right, so we're going to move on to a question for Jay. I have it coming in from Erin, who's curious if you have any specific examples of where a producer agreed to raise the standard of animal care in response to your litigation.
Sure. And so, yeah, I'm reluctant to name names right now, but I can give you an example. Generally speaking, so there was one case that we worked on with an egg company that was making claims regarding pasture access. And while we had evidence that they were actually sourcing some of their eggs from standard caged egg facilities, and what we were able to do in the course of the litigation was achieve a positive outcome where the company actually agreed to be subject to third-party audits to ensure that the products were actually pasture raised and not coming from a cage facility.
Great, thanks, Jay. And then a question for Dina from Tamara. She's curious, has Animal Welfare Institute investigated circumstances about and around, I'm sorry, I lost my sheet there. About and around New York City's over 80 wet markets or live slaughter markets, mostly mom and pop slaughterhouses in residential neighborhoods with under 20 employees?
Yeah, we're familiar with the situation with live animal markets, very concerned about them, obviously. We've not done any specific research into this. I think this is all top of mind now, and I think all of us will be looking at this issue and looking at ways that we can get more involved in this. There's potential for federal legislation on this issue, state legislation on this issue. There's a petition pending on the issue. So I think we all will be giving more work into this over the coming period of time.
Thanks, Dina. Yeah, that's really exciting. Another question for Nathaniel. It's time from Samuel. Samuel's curious if in cases where antitrust violations may harm consumers but benefit animals by reducing consumption due to raised prices, what should be animal activist perspective and actions regarding such cases?
So it's a good question, and I think there is arguably, at least in some cases, I think a tension, right? Because antitrust law really looks to what is good for consumers, and consumers, generally speaking, benefit from lower prices. And if you have lower prices, that could result in lower standards of care for animals because you trickle down or you margin squeeze down the supply chain. And I don't know that there's necessarily a good answer to it, other than to say that they aren't necessarily in conflict either. And as an example, right, the broiler chicken case that I talked about, we're pursuing claims on behalf of the growers who are feeling the margin squeeze because of an alleged antitrust violation. And that is having impacts, I think, on the animal welfare. Another example would be the eggs case, the processed eggs case that I was involved in, where the companies all got together and came up with what they called the UEP, United Egg Producers Certified Program, which they asserted resulted in a higher standard of care for the chickens, more space, healthier, happier hens. And there was an antitrust challenge there because it was a group of competitors coming together to reach an agreement on how they were going to treat the birds. And I think an underlying current of that was, well, why do they get to decide that this is the be all end all for what hen care should look like? Why can't we do something more, something different, or something better for the animals that the market might want? And I don't have a good answer other than to say I don't think they're incongruent, but there is a tension.
Yeah, Jay and Dina, I know both of you are steeped in this work as well, so if either of you want to comment on that, feel free.
Dina, do you want to go?
No, I will mention one thing that's going on that may have an impact to some degree. Internationally, we're in the middle of setting hen standards, the World Organization for Animal Health. And the meeting was canceled this year because of COVID-19, so it won't be until next year. So we've been working very hard to get confinement out of the international standards. Generally, in the United States, even though we aren't very good with our federal laws and state laws, there is concern about meeting international standards, and some companies here do want to be able to say that they need international standards. So it's very important that we do this work, and we've done standards for cattle, we've done standards for meat chickens and dairy, and right now it's egg-laying hens. So we'll see what happens there, but we're hoping if we can get good standards there, then the next step would be to pressure the UEP to at least adopt the international.
Yeah, I have a lot of thoughts on this, but the main thought I have is that I think it's a really excellent question and one that needs a lot more research and a lot of smart people thinking about, what the right answer is to it. I think some general thoughts I have at a high level are, I think it depends on the case. As Nathaniel was saying, there are some cases where I think it may be good for animals and some cases where it would be bad. I think a price fixing case where they conspire to raise prices is, a lot more questionable from an animal welfare standpoint than a case where they're conspiring to lower pay to farmers, which, if anything, I think decreases the cost of the company and makes it so they can sell the products, more cheaply. And so, yeah, I think it really depends on a case-by-case basis. I will say one kind of general thought that I have that I think further research is needed to bear it out is just, I think anything that really hurts the industry and hurts the biggest players in the industry is likely to be positive over the long run for animals, just because this massive concentration of political power that these companies had as a result of the massive amount of money that they have, I think is really one of the biggest impediments we have as a movement to, promoting change for animals. So I'm generally pro.
Yeah, and I would say promoting companies, products like Vital Farms, that have the higher standards. That's one way to impact the industry for sure, is by consumers supporting the higher welfare, supporting the higher welfare.
Okay, in the interest of time, we're going to start wrapping up. I really do want to thank everyone who's joined us today. We do look forward to everyone joining us again next Thursday at noon. And we are going to be turning a corner of sorts and start really focusing not only on how we can start repairing our broken food systems, but some real solutions from the ground up. And so we'll be indeed talking about greenwashing claims next week, but beyond that, we're actually going to start talking about how to really grow from the ground up, from the farm up, whether it be a regenerative agricultural system or a biodynamic system or organic system. And then, of course, the last panel, panel 6, we will bring it all together We will indeed study the responses people provided in terms of other action people can take here and now and in the future, and we'll indeed do our best to be responsive to those calls for action. So thanks again, and everyone, please be safe. Take care.
Thank you, Kim.